At 5, should police get a search warrant before collecting cell phone data during an investigation? That is the question put to the U.S. Supreme Court today. One local prosecutor called it a case of the law catching up to technology. And as R.J. Warren reports, the ruling could have an impact on how local police investigate their cases. Jay.
Well, that's right. When you think about it, our cell phones are the perfect tracking devices. They're with us all the time, and they're constantly sending out information to the internet. And it can often be very crucial for police to solve crimes. That's the foundation of the case of Carpenter versus the United States, where robbers in Michigan and Ohio stole large quantities of cell phones at Radio Shack stores. Cell phone data put Timothy Carpenter close to a number of the robberies which helped convict him. But police did not get warrants to obtain that information.
The ACLU view is always, look, if you want that information, it's available, but get a warrant to do it. In this particular case, they sought permission under a particular federal law where the standards are lower.
Butler County Prosecutor Mike Moser says electronic information played a part in the recent case involving Lester Parker and Billy Tucker. Cell data and Facebook messages obtained with a warrant put Tucker in Hamilton when he said he wasn't.
It was a wonderful opportunity for us to show that the alibi was false.
In fact, Moser argues that this kind of data can be even better than DNA. Moser believes the Supreme Court will follow precedent and require warrants, but leave room for occasions when there isn't time.
You could have a district court that's separated by 50 miles or more, so the availability of getting a search warrant in a hurry might be very limited. And the Supreme Court, I expect, will take that fact into consideration.
The ACLU also believes the court will do the same.
Let's say you have somebody who's been kidnapped. Let's say you have somebody who's gone missing, on a snowy mountain or in a forest or something like that. We all, the ACLU included, want law enforcement to have access to that information as soon as possible.
Now, in the case of Carpenter, his information was retrieved using the Stored the Stored Communications Act, which holds that if a third party, like a cell phone company, has your information, then police don't need a warrant to get it. Now, if Carpenter wins this case, the ACLU says that it goes a long way to protecting Americans' privacy. Jay Warren, 9 on your side, Hamilton.